We are here on the defendant's motion for exclusive use and use of escrowed funds. Mr. Shaw.
Thank you. Good morning, and Ivan Shaw on behalf of the defendant. It appears from the pleadings that, and from plaintiff's response, that they're amenable to using IOLTA funds for paying the cottage taxes. So that leaves just two issues: exclusive use of the cottage and use of IOLTA funds for the retainer. This is a short-term marriage, just 2.5 years. Defendant owned a cottage, premarital. He also owned a home in Rockford. He'd owned that home in Rockford for 10 years before the parties got married. He was in the process of selling the home when plaintiff filed for divorce. That home is since sold, and there's $100,000 in my IOLTA account. His plan was to move to the cottage once he sold his home. He had every reason to think that he could when he listed and accepted a purchase agreement because plaintiff had moved out and had not moved into the cottage. Unfortunately, after he accepted this offer, she did move into the cottage, and that's how we've gotten ourselves in this position. He has a minor child, a 16-year-old. He has that child half the time, and he needs someplace to raise her. Ideally, it would be in that cottage. My client's also concerned that if plaintiff resides in the cottage, that she'll damage it. He was distressed by some of the damage she allowed to have happen to his Rockford home by herself and her pets. So we'd ask that the court allow him to have exclusive use of that cottage. As far as the IOLTA request, he was served by email an order precluding him from selling the house, and he had 14 days to petition to have that restraining order lifted so that he could go through with the sale of his house. And he needed an attorney, but had no resources for one. So no retainer was paid. And so he's asking that he be able to pay a retainer at this point out of those sales proceeds. Like I said, he's owned the house for 10 years before the marriage. So all or most of that retainer money is his premaritally, or excuse me, that IOLTA money is his premaritally. And he's not asking for a significant portion of it for a retainer. And feels that he should be allowed some access to those funds so that he could have representation. So we're asking for exclusive use of the cottage and use of $3,000 out of the IOLTA to pay a retainer.
All right, thank you. Ms. Pelto.
Good morning, Your Honor.
Good morning.
Jessica MacPach is present. She stepped out right before we started to restart her parking, so she will be joining us. So, Your Honor, Ms. MacPach is asking that you deny the defendant's motion for exclusive use and instead grant her exclusive use of the party's marrying cottage. Ms. MacPach has an active personal protection order against the defendant. In her petition for that PPO, she laid out her request to live at the marrying cottage since at the time the parties owned 2 properties, and she was seeking a safe and stable place to reside throughout the divorce process. The defendant is the one that kicked Ms. MacPach out of their Rockford home before unilaterally listing the home at a price that she maintains was substantially below its value. He locked her out, preventing her from retrieving her items until he communicated through his attorney just a few days before closing that she had to come immediately and remove all of her things. He changed the locks on the marrying cottage, and he called the police on her when she had to remove an AC unit from the window to gain entry. She does concede that the defendant's name is the only one to appear on the deed of the cottage. However, the home was chosen and purchased by both parties during their engagement in June of 2023. Ms. MacPach sold her own home in order to contribute $32,686 to the down payment. And at the time, she put that money down in the full belief that she and the defendant were jointly purchasing the cottage. She was present at the signing. and they regularly discussed it throughout their marriage as something that would become their forever home. They made plans to move there throughout their marriage, leading up and until the moment that they separated. Ms. MacPach has nowhere else to go. She had intentionally reduced her income at the defendant's request in order to focus on caring for his 16-year-old daughter, as well as the parties' 2 properties. She's currently working to reestablish her small businesses where she does cleaning and selling homemade products at craft shows, but she needs time and stability in order to do so. The defendant works at Riley Remodeling. Upon information and belief, he earns approximately $6,000 a month and is more than able to find a temporary residence during this process. His current situation is one entirely of his own making since he entered the relationship and then he alone listed the house, entered into a purchase agreement, and agreed to a closing and move out date. Regarding stability for his daughter, the defendant perhaps should have thought of this before rushing to sell the second property at the same time he was entering into divorce proceedings. Upon information and belief, his parenting time schedule with his 16-year-old is 2 week on, 2 week off, where she attends school in Rockford. The Marion Cottage is over 80 miles away from Rockford. And while the governance of his parenting time schedule with his daughter is not an issue here, it is surprising that he would use her stability and well-being to justify having her being in the car for 3 hours each day of the school week. Regarding use of the escrow funds, Ms. MacPach does agree that it is appropriate to use them to get the Marion Cottage current on its property taxes. Further use of the funds, however, she asks that this court deny his motion, given his substantial income and ability to pay. Thank you.
Mr. Shaw.
Yeah, in response, he put a lot more than she did into the cottage. He put close to $100,000 when he purchased the property. And his name is on the title, so he has superior claim to that particular property. The PPO was issued ex parte. It has been objected to. He got the quickest date that he could. It's in August, so the court has not has not heard his side of the story yet, and he's confident that once you've heard his side of the story on the allegations in the PPO, that the PPO will not stand. He denies any physical abuse or stalking or any of these kind of allegations that would justify a PPO. The suggestion that he would not sell the property after he already had a purchase agreement is it was a suggestion that couldn't be fulfilled. The plaintiff did not need to quit her job to help raise his teenage daughter, and that's a red herring. He raises his daughter, and she certainly didn't need to reduce her workload to care for the child. But the fact is, she didn't want to do the job anymore. She wanted to sell these healthcare products at trade shows or festivals and this kind of thing. He was supportive of that and helped her with that. And that's what she does with her time when she wants to make some money. Otherwise, he didn't ask her to work during the relationship. It is not true that she didn't get notice of the sale. In fact, she feared that the house was going to be sold and she wouldn't have input on it, which is why she filed a restraining order that prevented the sale of the house. So she knew that this house was going to be sold. She consented to the sale. The complaint that she had short notice to remove her things is terribly disingenuous. When she does these trade shows, she makes between $1,500 and $3,000 a show. She's done several of them. And so she has the means to provide for herself. As for the daughter and the commute, he and his daughter and his co-parent are all on the same page about this move, and I don't think it's plaintiff's position to second guess that or use that as an argument as to why he shouldn't have the use of his property.
Mr. Shaw, where is your client living right now?
He just sold the property last month, or he just lost possession on Wednesday. So he's transitioning right at the moment. He's hoping to be in the cottage quickly, but at this point, he doesn't have a separate residence.
So where is he living?
We could ask him.
Mr. MacPach, where are you living right now?
I am living in my sister's basement.
Okay, thank you. All right. Well, there's clearly a lot of factual disputes in this case. The court has to, first of all, make sure that both parties have a place to lay their head. It sounds like both parties do have a place to lay their heads, although they may not be optimal. But at this point, I will grant the plaintiff exclusive use of the cottage temporarily. I will allow the parties to use the escrow funds to pay the taxes as they've agreed. I will also allow the defendant to use some of the escrow funds as pled. I think $3,000 was was that the request?
That was the request.
All right, I'll grant $3,000 of the escrow funds to be used towards defendant's retainer for his attorney. I will also grant an additional $5,000 to the defendant of the escrow funds to assist him in finding appropriate alternative housing. And is there anything for?
I'll prepare the order, Your Honor.
Yes, please. And
Thank
if you email that to Ms. Van Noller, that will be the quickest turnaround.